Most people believe family court is about evidence. They believe justice is decided by truth, disclosure, documents, witness statements, legal principles, and judicial reasoning. But many survivors discover something very, very different. Sometimes the process itself becomes the punishment. Not because they lack the evidence required, not because they lack the truth and credibility, but because the legal system slowly exhausts the nervous system, the finances, the cognition, and the emotional capacity required to keep participating in proceedings. And over time, participation begins to collapse. This is what I call litigation exhaustion. One of the least understood forms of coercive control inside modern family proceedings. This is Unmasking Justice. So welcome. Today we examine litigation exhaustion and procedural attrition, trauma and cognitive overload, financial depletion, procedural ambush, and how legal systems can unintentionally become environments where abuse continues through process itself. Because many survivors are not broken by one hearing, they are slowly dismantled by prolonged procedural pressure. And unless we begin understanding that the reality and properly continue confusing trauma exhaustion with personal failure, the system will continue to let mothers, women, and children down. So what is litigation exhaustion? Litigation exhaustion is a cumulative psychological, neurological, emotional, and financial depletion caused by litigation conflict. It is not simply stress, it is sustained nervous system activation over an extended time or period of time. Many survivors enter proceedings already traumatized by the perpetrator through coercive control, domestic abuse, financial abuse, intimidation, manipulation, financial instability, prolonged emotional fear. Then litigation begins. Disclosure requests, position statements, financial documents, applications, allegations, procedural directions, deadlines, hearings, cross-allegations, urgent emails, barrister correspondences, court bundles, forum shopping, and the nervous system never fully exists in this survival mode. It stays stuck. The body remains in a hypervigilant anticipation of fear, procedural uncertainty, and emotional threat monitoring. So this is why litigation exhaustion is not merely emotional, it is psychological and physically difficult for the body to absorb the litigation as ongoing danger. This is when we enter a freeze state, and eventually concentration deteriorates, memory weakens, sleep becomes fragmented, cognition is slow, anxiety rises, emotional regulation becomes harder, and participation itself begins to collapse. But courts often fail to recognize this process because exhaustion develops gradually, not dramatically. It has the same pattern as how coercive control manifests in a relationship. It's slow, it's accumulative. So the attrition model of control. One of the most important realities survivors must understand is this. Not all litigation behavior is genuinely about legal resolution. Sometimes the objective becomes attrition itself, wearing the other person down psychologically, emotionally, and financially until participation becomes impossible. This is what I call procedural attrition, a strategy where delay, reputation, uncertainty, procedural overload, and financial pressures become a mechanism of control. And because family proceedings involve children, homes, and finances, identity and emotional survival becomes the psychological stakes and extraordinarily high. Attrition can appear through repeated hearings, forum shopping, endless disclosure requests, disputes, last-minute evidence, unnecessary applications, prolonged negotiations, delayed compliance, excessive procedural correspondence, excessive bundles, or repeated challenges to settle the issue. Over time, the survivor becomes trapped in a permanent anticipation, always waiting, always preparing, always fearing what comes next. The body cannot stay in a survival mode for that long, and eventually the litigation itself becomes traumatizing, not only the original abuse, but the process surrounding it. The tactics being used in the hearing become part of the weaponization of the process. So the science of cognitive overload. Trauma affects cognition profoundly. This is not weakness. This is a neuroscience evidently based. A traumatized nervous system struggles with working memory, sequences of events, participation, speed, and emotional regulation, decision making, and information integration. Now, when you combine that with thousands of pages of disclosures of bundle information that's not necessary, legal terminology, procedural deadlines, changing evidence, adversarial questions, financial instability, and fear of losing your children, your home, and the blame for blame, he said, she said, this creates cognitive overload. The brain becomes overwhelmed by simultaneously demands that never end. And under that overload, recall becomes fragmented, clarity weakens, confusion increases, and emotional reactivity arises. but family courts frequently misunderstand this. The survivor may appear disorganized, emotionally inconsistent, and forgetful, overwhelmed, or unable to articulate clearly. Meanwhile, the other party may appear calm, procedurally detached, confident, composed, and strategically organized. Equality of arms is present, and this creates one of the most dangerous perceptions in the gaps within the modern litigation service, because trauma responses are often mistaken for credibility, and when credibility is not there, it creates a problem, when in reality there may be signs of nervous system exhaustion. And legal personnel that understand this, they use that to their advantage. This is where procedural stamina and truth becomes uncomfortable. This is another uncomfortable issue we need to discuss with honesty. Modern litigation culture often rewards procedural stamina, emotional detachment, legal fluency, financial endurance, and psychological aggression. Not necessarily the truth. The party with greater money, greater legal representation, greater procedural familiarity, or less emotional impact often gains structural advantage. Meanwhile, survivors may already be financially destabilized, traumatized, sleep deprived, cognitively overloaded, or psychologically depleted. This creates inequality hidden behind procedural neutrality, because the courts may appear fair externally while participation conditions remain profoundly unequal internally. This is one of the deepest failures in trauma-informed justice. And trauma-informed justice is the very tool that could help survivors in family court. The system sees equal procedure, but trauma reacts unequal participation capacity long before proceedings even begin. So the financial dimension of litigation exhaustion. Litigation exhaustion is not only emotional or neurological. It is economic. Family proceedings can become financially catastrophic. Legal fees, travel, court preparation, experts report, housing instability, employment disruption, administrative costs, emergency applications, childcare. Over time, many survivors enter the courtroom in a state of survival, economic survival, emotional survival, and financial fear directly affects cognition, because the nervous system cannot separate legal uncertainty from survival uncertainty. A person worried about homelessness, debt, losing utilities, feeding children, or financial collapse cannot always process litigation calmly. And this is why financial abuse and litigation abuse are frequently interconnected. The process itself becomes another mechanism of economic control and abuse, especially where prolonged proceedings drain savings, destabilize housing, weaken employment, or create dependency. And eventually, participation begins to collapse, not because the survivor lacks truth, but because survival itself becomes difficult. Communication becomes difficult. Recall becomes difficult. The body is now in a state of shutdown. So procedural ambush and late evidence. One of the most destabilizing aspects of litigation is exhaustion through procedural ambush, where the bundle arrives late at night for a hearing that's in the morning. Late documents, sudden allegations, unexpected evidence, last-minute applications. These tactics create intense nervous system disruption, especially for a traumatized participant, because trauma thrives on unpredictability of events. The nervous system becomes trapped in a constant state of alert, and this matters enormously under Article 6 of the Human Rights Act, because participation cannot be meaningful where someone is perpetually overwhelmed by procedural instability. Yet many survivors experience exactly this. So challenging positions, shifting allegations, delayed disclosure, repeated uncertainty, and procedural chaos. And over time, the nervous system stops feeling safe anywhere within the process. The body is in a state of overwhelm. This is why trauma-informed justice must examine not only what evidence exists, but what the process itself is doing to the participant psychologically. So when we ask and we look at the right questions, when exhaustion is misrepresented as failure or as lack of credibility, that's one of the deepest harms survivors carry. They carry self-blame. They begin believing, I should have explained myself better. I should have been more alert and remembered more. I should have stayed calmer. But you can't stay calmer, and you can't, you couldn't have properly coped in that situation, because it's not about what you can do. You are already in litigation exhaustion, and that is not weakness. It is a cumulative human depletion under prolonged procedural stress. The real question is not why did the survivor struggle. The real question is, why are legal systems still experiencing traumatization and re-traumatizing people to function while untraumatized participants under sustained procedural pressures? Why is there no equality of arms? This is reform conversation. We must now begin having these serious conversation, because justice cannot remain trauma blind while claiming procedural fairness. There is no fairness when there is no equality of arms. One person who's suffering from immense trauma cannot go against a heavily represented party. Many survivors are not destroyed by one event. They are slowly exhausted by prolonged systems of uncertainty, pressure, and procedural attrition. And this matters deeply because where participation is not present, justice cannot be seen to be done. Because participation rights mean very little if the process itself dismantles a person's capacity and autonomy to participate. Litigation exhaustion is real. Procedural attrition is real. And coercive control does not always end when proceedings begin. Sometimes it evolves, it mutates through the legal system itself, through the parties involved themselves. To every survivor listening, if you're ever mentally exhausted, emotionally depleted, overwhelmed, fragmented, unable to keep carrying those processes, that does not mean automatically mean you are weak. No, it means your nervous system has been surviving in a prolonged uncertainty for far too long. And systems must begin recognizing this reality if justice is ever going to become genuinely trauma-informed. A tick box service is not being trauma-informed. Trauma-informed follows the person, the process for each hearing. And this was my masterclass on the impact of litigation exhaustion on participation.